there is a hearing. The hearing is live, but Nick is not going to be in that. I can pull this up on stream and listen to it, but I don't think Nick was going to be in this because of the charges. I think that it's sealed. What do you mean it's over? Pull up the other stream. Like, you're just spamming bullshit and I can't figure out what the fuck you want. I have access to the Zoom call, like, directly. You guys want me to pull up, like, another person's stream? I really don't think he's going to show up. So I'm going to have to watch this fucking guy that nobody's ever heard of, because you guys are demanding that I show this particular stream instead of just joining the fucking Zoom call, because that's what placates you. Okay, let's fucking...
Presenting yourself at this point?
Yes, sir.
Okay. Count
himself,
one is second-degree possession, 25 grams or more of cocaine or methamphetamine. This is in violation of Minnesota Statute 152.022, subdivision 2, print A, print 1.
Ding dong is
the
not
maximum sentence for that count is 25 years in prison and/or a $500,000 fine.
Holy shit.
Count 2 is possession of ammunition or any firearm with the user of controlled substances. This is a gross misdemeanor, so the maximum sentence is 364 days in the Kandawai County Jail and/or a $3,000 fine. Count 3, endangerment of a child when present with a sale or possession of a controlled substance.
Oh, he's
again
fucked.
A gross misdemeanor. Maximum.
Do all your coke out, Nick, and kill yourself, you stupid motherfucker.
Someone has.
I'm going to warn
Zoom-bombed
everyone
it.
again. This is a court proceeding. If you were in a courtroom with me, it would remove you. So,
They can't stop the Zoom bombers.
any violation of that will be removed. Ms. Block?
Judge, I just disabled people the ability to unmute themselves, so I will work to unmute
Oh my God.
people as
The clerk
they need to
did it.
speak to
The
court
clerk
this
is a
morning.
hero.
All right. Thank you. Aside from Mr. Rekieta and Mr. Kornahachi, no one needs to at this point. Lastly, I think I was saying that the count 3 gross misdemeanor has a maximum sentence of 364 days and/or a $3,000 fine. Mr. Rekieta, you understand what you've been charged with? And second question, the maximum sentences associated with each count?
Yes, Your Honor.
All right. Now,
Yeah,
I
Your
don't mean
Honor.
to insult your intelligence, given you are an attorney, but it's important that I know that you understand your rights here. First of all, you are presumed to be not guilty of these charges. It is the state, not you, that has to prove what has been alleged in the complaint with evidence beyond a reasonable doubt. You have a right to trial by jury. All members of the jury would have to agree that the state had met its burden of proof beyond a reasonable doubt before you could be convicted. You have a right to counsel. You have a right to represent yourself, of course. If there's a trial, you could give your side of the story and testify, but you also have the right to remain silent. Indeed, you don't have to prove anything, so you don't have to say anything. If you remain silent, the judge can't make a comment about that. The prosecutor can't make a comment about that, nor can the jury take that into consideration. You have a right to confront, challenge, or cross-examine anyone who testifies against your interest. You have a right to call witnesses and the power of subpoena. You have a right to all of the state's discovery before trial,
You have a
and
right to being ding-donged.
including
The
exculpatory
ding-dong is people in the Zoom
information
call
and evidence.
harassing the
And
judge by, like,
at the
pressing
end of the
buttons
day,
that cause
if you
sound
think the court
effects.
made some mistakes or a jury made some mistakes, you have a right to appeal. Any questions about those rights as I've explained them?
No, Your Honor.
This is a
Dude, he
Rule
sounds
5
fucked
hearing.
still.
Sometimes
He's
we
going
call
through
it a
DTs
bail
or something.
hearing. We'll set this for a Rule 8 hearing. Under the rules, you have the right to have that hearing within 14 days of today's hearing, but you could waive that as well, given your right to seek counsel if you so choose. Do you want this scheduled within 14 days, a Rule 8?
No, Your Honor. I'd like to waive that. We can combine it into a contested omnibus hearing. So
He's-
All right, so we
He's
for
he's
today's
waiving his
purposes,
right.
combine
He's
Rule 5,
waiving his
Rule 8.
okay. He's
Yes, sir.
waiving his right to an attorney so that he can do the bond hearing right now. Because if he has, what he doesn't want to do is stay in jail for a week or two so that he can get counsel and contest the bond. He's going to try to do it himself. That's what he's doing right now. That's very stupid. You don't want. He's fucked up. He's a
Let's hear
retard.
what the state is requesting.
I didn't say it, but you also have the right to have me read the complaint today.
No, wait a minute, right, sir.
All right, very well. Mr. Kornahachi, what is the state requesting as far as release conditions?
Yes, Your Honor. The state is requesting $50,000 unconditional. In the alternative, we would agree to RPR with standard drug conditions, which would include no use, random testing, no use and possession of firearms, contact probation as directed, don't leave the state without permission from the court, remain law-abiding, keep in contact with probation, and other standard conditions.
He will accept that. It's very generous.
Mr. Rekieta, any objection to those conditions?
No, Your Honor.
I object to the $50,000 bail. I think it's unduly burdensome and in violation of the Eighth Amendment.
All right, what about the conditions?
Release conditions sound fine.
Dude, he is fucked.
All right, the court will set unconditionally amount of $50,000, cash or bond. Conditionally, you'll be released on your own personal recognizance. In all instances,
he got what he wanted.
Need to be.
I was wrong. He got exactly what he wanted. He's walking out today.
Conditions are as follows: abstain from the use of alcohol or any mood-altering chemicals not prescribed by a physician. That will be subject to
the
random
contact
testing.
release. He may not be able to stay at home because he's not allowed to have contact with the other co-defendants. He can stay with his wife. They might have April leave.
Possess any weapons, firearms of any nature, or be in the presence of anyone with a firearm or dangerous weapon, and do not leave the state of Minnesota without prior approval of the court. Any questions about those release conditions?
Yes, Your Honor. Did you say 50 or 15,000?
50,000. 50.
Thank you, Your Honor.
Okay, let me ask this. Do you still want a speedy omnibus, or can it be scheduled in normal course?
You rescheduled in normal course, Your Honor.
Very well. Madam Clerk, do we have a date for that?
I'm sorry, Judge, I'm just going to...
The release conditions were either $50,000 bond or promise to come back to court and obey certain conditions. So I think he's debating in his head if he wants to abide by the conditions or if he wants to just pay up the $50,000. It's they're not asking for much from him,
right?
Yes, sir.
Okay, so yes, in person.
And I'm sorry, Your Honor, just to clarify, timelines are waived?
Yes.
And Madam Clerk, just so the court is aware, Kristen Pierce is handling this case going forward.
He's got handcuffs on.
All right, thank you.
You're welcome.
So while we're waiting for the date, $50,000 bond, cash or surety, which means he can
And the
pay.
matter has been assigned with Judge Fisher. I'm looking at Tuesday, August 20th at 2:45.
Good for the state.
Judge
Without having a calendar sounds great.
Very well. Any other business we can conduct?
Now,
Yes,
if you have this, apologies. Go ahead.
Your Honor, I have requested to see two of my clients and have been forbidden from doing so. I would like to see them before this.
Is he going to represent April and Kayla?
He's going to represent his
I'm not
wife.
understanding your request. Can you repeat it?
As two of my clients are set for arraignment today, I have requested to see them. They have both requested to
Oh my
speak to
God.
the attorney, who is me, and they have been prevented from doing so up to this point. I was wondering if we could get an order to allow me to at least speak to my clients before they come into their first appearance.
Kornahachi?
Your Honor, I'm not sure if the court is aware. April Multi has been released.
Okay.
And then I believe the other person who's referring to is his wife, Kayla. Is it Rekieta? Rekieta. I'll leave it to the court's discretion. They are charged as co-defendants. I believe she would have to waive any conflict, etc.
There's
but I
huge
don't
conflict.
take a position.
And to be frank, I don't know if that's a waivable conflict at this point, given they are co-defendants. But there's no request from the state that obviously they are married, so there's no request that they be separated. True?
Correct.
So it's not DV.
Well, it's an issue of denying counsel to Ms. Rekieta, so I will grant the request and leave that as an issue for Judge Fisher. At least to get us through the arraignment this morning.
Thank you, Your
Mr.
Honor.
Jailer, are you able to make accommodations? Mr. Rekieta, how much time do you need?
Not long, just about 15 minutes, Your Honor.
Can the jail accommodate that?
That'd be up to the jail administrator, Your Honor.
I'm sorry?
I would have to talk with the jail administrator.
All right. If they have any difficulties with that, the jail administrator, since I'll be in these proceedings, should contact Chief Judge Beckman.
Thank you, Your Honor.
Thank you. All right. Since Ms. Rekieta is not available, at least for the next 15 minutes, do we want to take the next matter?
Fine with the state, Your Honor.
Do we want to interpret the case next?
Which case?
The interpreter case?
Sure.
Okay. Thank you, Your Honor.
Thank you, Your Honor.
Okay, so we're going
that's
to pull
crazy.
down the screen. They're going to handle some other cases. I'll leave it going and see if Nick's wife for arraignment.
Yeah, okay, Chet, you are tasked, if you're one of these people watching this, spam me if Kayla gets onto screen. I was very, very, very surprised that he showed up, because I was certain that it would be sealed. The entire thing would be sealed because of the charges. I'm also surprised that he got the bond that he wanted, because his thing was that he did not want to consult a public defender for his bond, because in doing so he would have to be in jail over the 4-day weekend or 3-day weekend, however long Labor Day is. So he represented himself and basically just wanted to get out as soon as possible. And he's going to try and do the same for Kayla. So it's definitely a conflict of interest, but I guess if the state doesn't really give a fuck, then he can represent her as well, assuming that she waives her rights and understands that there's a conflict of interest. It kind of indicates that Rekieta thinking that that's going to happen means that there was no DV, and that they basically are going to present the same defense with each other. It's not going to be a thing where Kayla says, oh, it was his fault, I told him not to, that kind of stuff. Because if she was going to testify against him, then he can't represent her because of the conflict of interest. But which is why they warn you of that, because you're effectively, you're being prosecuted as a single entity, as a married couple that are completely conspiratorial in the crime. So that's the concern there. The charge has been upgraded, and they've added something that wasn't on the public docket, which is what I expected. I did not, because of the drugs and the gun charge, they've also added neglect as an accessory to the drugs, I think. And the drug charge was upgraded from mere possession to like serious possession. He had more than a certain amount of cocaine, so they're charging him as a as like a dealer, like the upgraded charge that has a maximum sentence of 25 years instead of 5. So all in all, that's not a good look. They're basically going to be able to beat whatever the fuck they want out of him in terms of a plea deal. As far as, because his concern, as demonstrated by his decision to not get an attorney to handle the bond for him, is indicative that his main concern is to stay out of jail, obviously. So he's going to take whatever he can get in terms of a plea deal. And I'm still very hesitant to say that they'll probably try to give him anything besides the besides probation and court-appointed rehab. I will make a prediction right here and right now. He will fail his rehab. He will fail a piss test or something. I don't know. Maybe he's smart enough to find some way around it, but I don't know if he's at a point in his life where he's really going to like try and turn it around and actually stay sober. I did find it very shocking, like how the alcohol withdrawals were obviously physically affecting him. He was not coherent sounding. He wasn't lucid sounding. He sounded very like as if he were still a drunk, but I suppose that's just a consequence of the DTs and stuff. It was not April who snitched. So April's already out, but that's because she doesn't have the child neglect or the gun possession charge. So she has mere possession, and she didn't have the serious possession charge. So they just let her out because there's zero reason to have like a bond hearing for her because of how minor her charges are. So she was just caught up in the possession. His throat sounds raw. Yeah, he will not stay sober. And he seemed kind of smug and irritated. I mean, like the smug has obviously been cleaned up a little bit, but he still seemed just like kind of cocky and arrogant, despite being in handcuffs and like a thing. So he'd be shaking if he had DTs, maybe.